Good afternoon or good morning, depending on where you're located today. Thank you so much for joining us today to celebrate this webinar launch of a special edition of the Australian Journal of Asian Law on Indigenous Peoples and Law in Asia. My name is Tim Lindsay, and Dr. Helen Paussacker and I are the executive editors of the Australian Journal of Asian Law. I'm also director of the Centre for Indonesian Law, Islam and Society here in the Melbourne Law School, which, with the Journal and the Asian Law Centre, is the co-host of today's seminar. Let me begin by acknowledging the traditional owners of the unceded land on which Melbourne Law School is located, the Wurundjeri, Woi, Wurrung and Bunurong peoples. I recognise the unique place held by Aboriginal and Torres Strait Islander peoples as the original owners and custodians of the lands and waterways across the Australian continent, with histories of continuous connection dating back more than 60,000 years. I also acknowledge their enduring cultural practices of caring for country. I pay my respects to elders, past, present and future, of both the Wurundjeri, Woi, Wurrung and Bunurong people, and to the traditional owners of the lands we've discussed in this special edition of the Journal. I acknowledge the importance of Indigenous knowledge in the Academy. Our seminar today has two main sessions in which our authors will present 10-minute overviews of their articles in the special edition. After they've presented, there'll be 5 minutes for a question time at the end of each session. If you want to ask questions, then you'll be able to put your questions in the Q&A facility at the bottom of your Zoom screen, and the chair will moderate them, asking our authors to respond. And of course, we'd also encourage the authors to ask questions of each other. I think you'll have a lot in common and a lot to discuss. Before we start, I want to thank all our authors for being willing to speak today, and of course for contributing such excellent and interesting papers to this special edition. Dr. Helen Paussacker also deserves our thanks for her tireless work coordinating with you all and ensuring successful publication. I'll also thank Catherine Taylor, the Centre Administrator, for her hard work behind the scenes to make this Zoom webinar run smoothly. I now need to introduce our two chairs, who are of course editors of the edition and contributors as well. Got our money's worth out of you, I think. Professor Kirsty Gover will chair the first session. She's a professor here in the Melbourne Law School, where she is also a Program Director of the Indigenous People in International Comparative Law Research Program. Kirsty is a graduate of the New York University JSD doctoral program, where she was an Institute for International Law and Justice graduate scholar and a New Zealand Top Achiever doctoral fellow. Kirsty teaches and writes about domestic and international law affecting Indigenous peoples in Canada, New Zealand, Australia and the US. She's the author of Tribal Constitutionalism, States, Tribes and the Governance of Membership, an Oxford University Press publication. Our other editor for our special edition is Associate Professor Jonathan Lilliblood of the Australian National University Law School. Jonathan will chair the second session. Jonathan was born a member of the Pa'o Indigenous people of Shan State. He has a PhD and JD from the University of Southern California, an MS from the University of Washington, and a BS from the California Institute of Technology. Jonathan describes himself as a scholactivist, with his research connected to his advocacy work with international aid organisations and others, bridging academia, government and civil society. And his research is heavily based on fieldwork in the region. Jonathan's most recent book is Indigenous Identity, Human Rights and Environment in Myanmar, Local Engagement with Global Right Discourses. So again, as you know, you all know, Kirsty and Jonathan were guest editors of this special edition. So my thanks go to them again for all the work they did to make this edition possible. It's a real pleasure to invite them both now to present an introduction to the special issue before Kirsty chairs the first session. Thank you so much, Kirsty and Jonathan.
So thank you, Tim, for that excellent introduction. I'll go ahead and start with the initial comments, and then Kirsty will finish up with the final comments for the introduction. I also want to thank the authors who contributed to this journal. It was a very important issue that assembled very useful insights from each of the authors, and we're extremely grateful for the time and energy and effort that they dedicated to this project. We also want to thank Tim Lindsay, Helen Pausiker, and Catherine Taylor for all of the behind-the-scenes efforts to make this project possible. There is quite a bit of hidden labor that most people, even who are reading the journal, are not aware of, and this project would not be able to function without their support. I'll also make a statement of acknowledgement of country. I'm joining you from the campus of the Australian National University, and this university is situated on the lands of the Ngunnawal and Ngambri peoples. We pay our respects to the elders past, present, and emerging, and likewise, we pay our respects to all Indigenous peoples around the world, including the ones who are the focus of this thematic issue. My comments for this introduction deal with context and purpose. Basically, I want to try and help readers understand the context that drove this project forward, and then the particular focus that we undertook as editors in assembling the contributors for this thematic issue. Beginning with context, I'll state that a lot of the motivations were tied to pre-existing literature that has existed over the past decades regarding the growth of international Indigenous movements. Quite often, these studies dealt with the efforts at transnational coalitions that have been built to try and advance Indigenous rights within international law. All of these activities, in some form or fashion, reflect pre-existing connections between different Indigenous peoples around the world. These relationships between Indigenous peoples predate and continue to exist concurrent to the prevailing state-driven international legal order. There has been a growing body of literature from the scholarly community addressed to these international Indigenous movements. However, most of the discourse from the scholarly community has been dominated by sources based primarily within the Americas and also within Oceania. So Oceania includes Australia and New Zealand. This is particularly true with respect to legal studies. And as a result, there is a need within the scholarly community and within legal scholarship specifically to give increased attention to Indigenous movements in other areas of the world. For the purposes of this thematic issue, we decided to focus upon Indigenous movements within Asia. The reasoning being that, number one, Asia is adjacent to Australia, and so hence has an added focus of concern for Australian scholars. And then number two, that there are Indigenous movements in Asia that do not receive attention from international scholarship, and hence their deficit in understanding about the nature of Indigenous movements within the Asia-Pacific region. To address this particular call, we are responding with an initial step that is part of a broader research agenda to study the relations between Indigenous movements in Asia relative to international Indigenous movements. In order to fulfill this particular purpose, this thematic issue focuses on assessing the current status of Indigenous movements within various Asian countries, with the hope that this provides a preliminary step that leads to future studies about the connections between Indigenous movements in Asia and the international Indigenous movement as a whole. The collection of contributed articles that you see within this thematic issue reflects a review of different Indigenous movements in different countries in Asia. And the hope is that together, as an ensemble, they provide a foundation for subsequent studies that enable larger assessments about Indigenous movements among Asian countries. I'll stop there, and I'll hand over to Kirsty, who will now talk about the major themes that we picked up on across the various articles.
Thanks, Jonathan, and welcome to everyone. I'm speaking to you today from Melbourne on the lands of the Wurundjeri peoples of the Kulin Nations, and I wanted to begin these brief comments by acknowledging them and the persistence of their law on this land. I propose to just say a couple of things very briefly about the thematic underpinnings of this special issue. Uh, the first is in thinking about the scope of the collection of chapters. We were very keen to have the authors write as local experts and to focus on whatever issues they felt were most pressing for the communities that they were writing about. So as we will hear, the themes of the chapters are varied, and that's entirely expected given the vast diversity of the region that we're examining. And as you might expect, all of the chapters focus in one way or another on the challenges that Indigenous peoples face in the realisation of their rights. One of the most long-standing and central challenges that all of the authors referred to in one way or another is the scope of the global legal category of Indigenous peoples itself. And as the contributions make clear, definitional issues have impacted the efforts of Indigenous peoples of Asia to assert their place within the global category of Indigenous peoples, and so also to draw on the resources and the rhetorical power associated with that designation. And to varied extents, this definitional debate has also made it more difficult for Indigenous peoples to successfully rely on their distinctive status in their dealings with states. And as some of you know very well, these international legal definitions are very state focused and very focused on state law, and they have perpetuated a distinction that both Jonathan and I commented on in our conversations about the chapters, a distinction between settler states like Australia, New Zealand, Canada, and the US, and recently decolonised independent states like many states in Asia. And it's evident that these debates, because they focus on the objective, tend to focus on the objective characteristics of states, that they also tend to obscure the common experiences shared by Indigenous people globally. And those experiences might be summarised as follows: the experience of being overrun, overruled, or displaced by larger or better resourced groups exercising or enabled by public power, whether or not we call this colonisation. And I think working on editing the chapters in this volume has reaffirmed for me, and I think also for Jonathan, that it's really important that the injustice of this experience is understood from the perspective of the groups enduring it. And it may not matter so much who is perpetuating or generating that injustice, the same. And I wanted to make the point that all of this is in keeping with the insights offered by the resurgence of approaches to international law that centre Indigenous perspectives and Indigenous knowledge, including Indigenous international relationships and all the diplomacy that entails. And this one place where we can see these dynamics and this Indigenous knowledge showcased is in the field of scholarship that Jonathan's associated with, making up the field of fourth world approaches to international law. So I draw our attention to that question of perspective because one of the aims of this issue was to help, perhaps in a small way, to build the kind of global solidarity that will support Indigenous peoples in Asia, as Jonathan already said, and also to promote the elevation generally of Indigenous knowledges and perspectives in international law and elsewhere. So having said that, I am delighted now to introduce the first of our speakers, Professor Kam Swan Halsing from the Department of Political Science at the University of Hyderabad. And I invite Professor Halsing to speak to his chapter, which is entitled Indigeneity, Territoriality and Citizenship in Northeast India. So Professor Halsing, I'm pleased to hand over to you now, and I'll let you know when you're getting close to the 10-minute mark.
Let me first of all thank Kirsty and John for having invited me, and to Helen and Tim for overseeing the special issue to its fruition today. I'm really delighted to be a part of this project. My draw here is, my contribution here is to look at indigeneity, territoriality, and citizenship in Northeast India, and how the contemporary discourse on indigenous politics might have important bearings on the way we look at these complicated as well as complex issues. So the first thing that draws my attention is to unpack, as it were, the indigeneity puzzle, as it were, by looking at how, for example, some of the existing literature which seeks to define indigeneity on the basis of the competing principle of first occupancy or prior occupancy, taking a cue from a Jeremy Weldron influential article, is used as a point of reference to define and determine who can be labeled as indigenous. And as we know it, the two principles become deeply problematic in some of these deeply divided and complex players, which are marked by multiple as well as competing claims of indigeneity. For example, the first principle of first occupancy, for example, which seeks to privilege the people who occupied the territory first as a determining factor for, entitling territorially concentrated groups with certain indigenous rights, is deeply problematic because it casts a heavy burden on history to prove that they have indeed been the first occupant or settler of that particular place. Look at, for example, the case in India where some of these so-called indigenous people like the Gonds and the Mundas in central India are considered to be indigenous in central India in contemporary discourse, but sometimes they are not the first occupants of central India because they are historical evidence to suggest that the Hindu kingdoms precede the migration of the Gonds as well as the Mundas in those places. And the second principle of prior occupancy also becomes problematic because if colonial conquests were used as a timeline, to mark off the indigenous from the non-indigenous, it does not apply universally across the board because there are places in which colonialism have never set in. And in those places, how do you then use, colonial rule as a marker of indigeneity or non-indigeneity in those places? And this also becomes deeply problematic, especially in Northeast India, which is the case of my study here, precisely where you have several waves of migration. And there are multiple as well as overlapping claims of territoriality. And this is precisely where I seek to draw attention on the relative and situational nature of indigeneity in Northeast India, right? And I think this is something which has resonance in other places where you have multiple as well as competing claims, in places where you have multiple as well as overlapping territorial claims in those places. What remains interesting, however, is that the idea and practice of indigenous politics and discourse has evolved over time from a prosaic description in the 1970s to something which has a concept with considerable power in contemporary times. And this was a point that was highlighted by Benedict Kingsbury in the 1990s to suggest how the idea of indigeneity has migrated over time in ways that now encapsulate a range of ideas as well as practices which center around the protection or recognition of the rights of indigenous people to maintain distinctive culture as well as institution in 1957. The ILO Convention of 107, in 1983, with the working definition, which seeks to set up as 4 definitional criteria to determine who is indigenous: historical continuity, distinctiveness from other societies, the non-dominance, determination, preserve, develop, and transmit the ancestral territories and identities, down to 1989, when you have the explicit recognition of indigenous people to self-determine and also recognize the right to maintain and perpetuate their own institutions, way of life, and development in ways that help to maintain and develop their identities, language, and religion within the framework of the states in which they lived. And in 1993, you have the proclamation of the Year of the Indigenous Peoples, and by 2007, you have UN Declaration of Human Rights, which essentially give a lot of considerable power in ways that allows the indigenous people to assume a very significant slot in international in international spaces in ways that help them establish wide transnational linkages. In the context of India, the problem of indigenous politics or discourse is centered around, for example, some of the foundational debates in the 1940s, in the 1970s and the 1980s, where there is a reluctance to recognize the aborigines, as it were. Z.S. Gure, for example, one of the first important scholars who have worked on the tribals in central India, consider, for example, that the so-called aborigine, which he termed them as aborigine so-called, were integral part of the Hindu society, and they cannot be treated as a distinctive society as such. And he considered that it would be unscientific to label, the scheduled tribes or the Adivasis or the aborigines in central India as original owner of the soil, because it does not reflect existing social as well as the political realities there. And Andre Bethea is another very influential sociological anthropologist who would, for example, consider that it would be absurd to consider only the tribals as indigenous, given the blurred distinction between caste and tribal groups in different parts of India, which have competing claims over indigeneity in the place in which they are either first occupants or that they occupied prior to the arrival of colonial rule in those places. B.K. Roy Berman take this forward to kind of consider that it would be unjustifiable to have indiscriminate use of indigenous people to refer to all tribal peoples simply precisely because they do not have equal ethical responsibility to the nature. And the Indian position, the legal and political position of India is that it seeks to avoid the term indigenous people precisely because of its legal as well as political implication, because the idea of indigenous people is tied up with the right to self-determination. And therefore, the Indian state has, since the inauguration of its republic in 1950, leveraged a set of parameters which include primitive traits, cultural distinctiveness, geographical backwardness, signness of context, or backwardness, which are neither strictly anthropological but driven by political consideration as well as administrative efficiency. And the result of which is that you have very inconsistent practices of recognizing or securing the rights and interests of indigenous peoples in not only in Northeast India but also across India. So the case that I have in this contribution is the case of the Zhou, who are colonially referred to as the Kukichian as well as the Lusai group. And what is important about this group is that they straddle across the India-Myanmar as well as Bangladesh borders, and they have been dispersed across predominantly across 5 states of North India: Assam, Manipur, Meghalaya, Mizoram, and Nagaland, as you see in the map, as it were. So what is interesting is that the Zhou have a contiguous occupation across the Indo-Myanmar borderland, prior to the arrival of the colonial Raj, and this has been borne out not only in colonial records but also in the local royal chronicles of the Meitei as well as the Tripura chronicles, as it were. So what is interesting is that the Zhou have, in fact, also witnessed, like most other, indigenous peoples in Northeast India and central part of India, several waves of migration, which, for example, one of the consensus is that they have more or less migrated from the Yunnan province around 9th century and reached to Burma around the 14th century. And they have another waves of migration from around the 14th century when they migrated westward from Upper Burma to different parts of Northeast India, and the existence of the dispersion of the Zhou communities have been recorded very well, as I pointed out, by the royal chronicles of the Meitei kingdoms, or which is called Manipur kingdom, as it were, and the Tripura Sri Rasmala, which predate the beginning of the region of official records. And what is also interesting is that the kind of interaction and exchanges between these valley-based kingdoms and the hill indigenous territories are one which is marked by, kind of equal relationship, which is also a characteristic feature of most of these indigenous people, because many of these indigenous populations around the world are never conquered by the adjacent kingdoms, or even by the colonial rule, as it were. And the result of it is that many of these constituent segments of the Zo, for example, the Sukte and the Silo chiefs, which emerged in Chin Hills in Burma today, and the Silos in Lusai Hills in Mizoram, modern Mizoram in Northeast India, for example, continue to remain unconquered, and they have never been tributary either to the valley-based Manipur, Tripura, or the Ahom kingdoms, that is in Assam in Northeast India. And drawing from these historical rights, or the historical existence of being independent as well as sovereign, the indigenous Zo have been trying to negotiate the terms of their political integration in ways that accommodate their distinctive right to perpetuate and protect their culture, their institutions, and their access to land resources as well as territory. But however, as you would see in the recent contentious political development, there is a majoritarian rise and consolidation of the Métis and as well as certain groups within the Naga communities, which now seeks to exclusively, corner the benefits of indigeneity by invoking a problematic and deeply contentious migration timeline of the 1850s, when there was this idea of Sepoy community in around the Imphal Valley, which alluded to the migration of a specific segment of the Zo community, and now being used and appropriated to kind of castigate the whole entire Zo community as if they are illegal immigrants, which in effect is oblivious to, as I have already pointed out, to their prior settlement before the arrival of the colonial rule, and much before the royal chronicles began to have official record. And using 1951, 1961 census, for example, as the basis of National Register of Citizens to determine citizenship rights, for example, become deeply problematic, because this is insensitive to the actually existing practices of group differentiated citizenship, which allows the Zo indigenous tribals unrivaled access to land resources, jobs, as well as employment opportunities. And my contention essentially is to kind of leverage the idea that indigenous discourse and politics have to be sensitive to the relative and contextual dynamics in specific locality in which it has traction, and that wherever indigenous politics and discourse sometime seeks to override existing citizenship rights, like the kind of group differentiated citizenship rights that we have in Northeast India, my contention essentially is that we have to reconcile group group differentiated citizenship rights and privilege that if indigenous discourse seeks to dissolve or disrupt that, because it have important implications on disrupting as well as dissolving existing historical rights that indigenous people like the Zo have. And this is precisely where the idea of dominant and non-dominant indigenous population, I think, is critical here. And this is also precisely why indigenous discourse is about, providing a bulwark of non-dominance, not only against mainstream society, but also in places marked by multiple as well as competing claims of indigeneity, where dominant indigenous group might override the right of indigenous community. And my case study amply shows that it is important to be mindful of the contextual and relative nature of how indigenous politics and discourse might unravel in place marked by multiple as well as competing indigeneity claims. Thank you so much.
Thank you. Thank you so much, Professor Halsang, and thank you for contributing your excellent chapter to this volume. It's my great pleasure now to introduce our next speaker, Professor Rakiba Nabi from the Department of Law at the University of Chittagong in Bangladesh. Professor Nabi will speak to her chapter that's titled Safeguarding Unique Ethnic Cultures in Bangladesh, Autonomy and the Right to Self-Determination. Over to you, Professor Nabi.
Thank you so much for giving me the floor. I'm really grateful to the Journal Committee and the editors for considering my paper in the Australian Journal of Asian Law. My article published in this journal is titled Safeguarding Unique Ethnic Cultures in Bangladesh, Autonomy and the Right to Self-Determination. It is a little bit connected with my earlier paper presenter, Mr. Swan Housing. I'll take you to the core problem of this article. So a bit historical context here lies, and then the core framework, legal framework, the 1997 Peace Accord, and what international law requires, then the obstacles that remain, and my argument for the forward. Bangladesh has over 54 distinct ethnic groups. The Chittagong Hill Tracts, that is the CHT, is home to the largest concentration, the Chakma, the Marma, the Tripura, and many others. These communities have inhabited this land for centuries. They carry their own legal traditions, customary land systems, and cultural identities. For decades, they have sought recognition of their right to self-governance and cultural protection. The tension is between that aspiration and Bangladesh's own constitutional framework, which emphasizes territorial integrity and a unified Bangladeshi national identity. My central question is this: is internal self-determination, meaningful autonomy within the state a sufficient and legitimate response to the injustices these communities have suffered? Or does the scale of that injustice justify the far more radical option of remedial cessation under international law? I think in this paper that a strong internal autonomous framework grounded in international law in Bangladesh's 1997 Peace Accord is the legitimate and viable path. There is no option of cessation. If we go to the historical moments there, the main law that guided this region is the CHT regulation of 1900 that established legal protection for indigenous governance and customary land rights. That regulation gave a formal recognition that CHT was legally distinct from the rest of the Bangladesh. In 1960 to 63, the most damaging rupture is the Pakistani government displaced over 100,000 indigenous people, primarily Chakma, to construct the Kaptai hydroelectric dam. No consultation, no compensation, no reparation. This injustice was never remedied, and it created the foundational land grievances that still drive CHT politics. In 1979 to 1985, in this time, the state relocated approximately 400,000 Bengali settlers into the CHT under a deliberate settlement program, systematically over indigenous customary land tenure. These two events, the dam and the settlement, drove the 1977 armed insurgency and created the 90,000 people displaced households, which was still unresolved. Later, the 1997 Peace Accord, which was a landmark settlement, as it ended 2 decades of armed conflict and represented Bangladesh's formal acknowledgement that the CHT required distinct governance. It established the CHT Regional Council, 3 district councils, a ministry, under CHT Affairs and the Land Dispute Resolution Commission. It recognized the Juma cultural identity, customary land rights, and provided for the repatriation of displaced persons. In international legal terms, it constitutes a formal recognition of internal self-determination. The architecture was right, but implementation has been severely delayed. Only 12 out of the agreed 33 governance subjects have been transferred to the Hill District Councils. The Land Commission has resolved no disputes in the last 25 years. Implementation has been frozen since 2020. A High Court ruling which declared that the Regional Council Act was unconstitutional, potentially dismantling the 1997 Accords institutional core. So the framework exists here in Bangladesh, in CHT. What is missing is the political will to honor it. The international legal framework I have covered in my paper as a background, that is international legal framework, that is what is internal and what is external self-determination. I fit the CHT problems under the international framework, where actually external self-determination, I see it is reserved for the colonial situations. The contested doctrine of remedial cessation exists as a last resort under extreme systematic rights denial with no effective internal remedy. I mentioned the Kosovo advisory opinion, which is frequently cited, but the ICJ did not codify this as a general right to cessation. So political context in that case is entirely different from the CHT. The CHT does not meet the remedial cessation threshold. A negotiated...
1 minute.
1 minute. So the challenge is, which lies in Bangladesh, that is the Kukichin National Front secessionist demand is here, who expect different Kuki land. Then Operation Uttoron's going military presence is here. The military is still lived in CHT, and the Constitution of Bangladesh does not directly recognize the term indigenous. So my recommendation is that we have to at first implement the 1997 Accord. We have to strengthen the political pluralism, and we have to implement the inclusive governance and accountability of the Bangladesh government. So none of this is radical. All of it works within the Bangladesh's existing constitutional framework. The architecture is already exists. Nations and minorities can find a equilibrium, sovereignty preserved, while minorities govern themselves and cultivate their unique identities. So my last word is that CHT is not a problem without a solution. The solution exists in the 1997 Accord and in international law. What it requires is genuine political will to implement what was promised almost 30 years ago. Thank you so much.
Thank you. Thank you very much, Professor Nabi, for your presentation and for your very interesting chapter. And thanks for your hard work on our behalf and submitting it and editing it. I'm really delighted to introduce our next speaker, Sumiat Nortet, who is a PhD candidate graduating this year, I've been told, at the ANU College of Law, Governance and Policy. Sue will speak to the paper that she co-authored with Associate Professor Jonathan Legerblad, one of our editors here, and the paper is titled The Status of Indigenous Rights Movements in Myanmar's Current Conflict. Over to you.
Thank you for the introduction, and thank you to the organizer for putting together this launch event. My supervisor and I write an article named The Status of Indigenous Rights Movement in Myanmar's Current Conflict, which is a deceptively simple question: what has happened to indigenous rights movements in Myanmar since the military coup of February 1st, 2021? The answer, as this paper shows, is kind of complicated and also urgent. So I will take you through the key findings, starting with the problem that sits underneath everything else, which is the question of who gets the name Myanmar's people. So I move to the second slide, which is contest the ground, who gets name. So the starting point is terminology, and this is not just a semantic issue. For most of the people from Myanmar and then Myanmar post-independent history, the state has used the term Dayinda. I write it down in Burmese language. We spell it like Dayinda, so which is translated as a national races to classify its population of 135 fifth category. This taxonomy was built under successive military regime to serve a process of Burmanization, which is like privileging the Burma majority and marginalizing everyone else. It is embedded in the 1982 citizenship law and 2008 constitution. It has real legal consequences, affecting who can vote, who own land, and practice a profession. So what our paper treats is a counter movement, minority civil society organization, particularly through the coalition of indigenous peoples in Myanmar, in short form we call CIPM, have asserted a different Burmese language term, which is Pane Dayinda, meaning original dwellers. This definition centers ancestral continuity, pre-colonial territorial connections, cultural distinctiveness, and non-dominance. The criteria that align with the UNDRIP and ILO 169 rather than the state citizenship scheme. So the point is that naming is itself an act of self-determination. So the battle over this term reflects a deeper conflict over who has the authority to define the peoples from Myanmar and on what basic rights attached to them. So let's move to what happened before the military coup emergence and limits. So indigeneity as a formal political claim in Myanmar is surprisingly recent, while a current National Union representative first self-identified as indigenous at the UN Working Group as far back as 1987. A momentum only really built around the 2014 ASEAN People Forums back in Yangon, where the Asia Indigenous Peoples Pact, AIPP, convened workshops with Myanmar minority. So this led to the formation of CIPM that I mentioned before, which grew to 28-member organization spanning the Arakan, Chin, Kachin, Karen, Karenni, Mon, Naga, Shan, and the Pa'o people. We listed all the 20 organizations in our paper. So under the Nationally for Democracy government from 2015 to 2020, there was genuine, if limited progresses. Government ministers attended indigenous events, and the War Indigenous Appeal drafted environmental regulation, and CIPM engages the UN Universal Periodic Review Mechanism. But these gains are kind of fragile, and the 2008 Constitution Article 37 declared ultimate state ownership of all land. And also 2012 land laws effectively erased customary tenure system. By the time of the coup, the indigenous rights movement has gained visibility and legitimacy, but has not secured formal legal recognition. So the constitutional structure kept the military embedded in governance, and that will soon matter enormously. So let's move to what happened after 1st February 2021, because we all know that the military coup reset the landscape. So the military removal of the elected government installed the State Administrative Council, in short form we call SAC. For indigenous movement, this is where the state became existential. The junta doubled down the old framework, using national races, languages to justify centralized authority, deploying martial law and forced displacement disproportionately against indigenous community. By the late 2024, UNHCR estimated over 1.95 million internally displaced, the majority in Karen, Kachin, and Rakhine states. Law has been weaponized. That the there is simply no accommodation for claims of self-determination under military rule. So on the other side, there is pro-democracy forces, National Unity Government, NUG, and there is CRPH, which is legitimate representative body, and another one is NUCC, which is National Unity Consultative Council. So these offer a different vision, a federal democratic alternative articulated in the 2021 Federal Democracy Charter, which include decentralization, human rights protection, and also proposed citizenship law that will replace the exclusionary category of 1982 citizenship law. So new cross-ethnic alliance have formed. So for example, Operation 1027 in October 2023 demonstrated what coordinated resistance can achieve. However, the pro-democracy unity remains fragile. The National Unity Government, which is top-down project, and its capacity to hold all parties together, including indigenous people movement with their own governance ambition, is genuinely uncertain. So what is perhaps more striking in our paper is what indigenous community are doing on the ground without waiting for either the hunter and also the pro-democracy movement, like which is NUG. So I'm going to list three for the sake of the time. So among the current community have been registering their own lands and mapping their own traditional territory using GIS system, asserting their connection to place in the middle of an ethnic conflict. And the other one is Chin. They have drafted a Chinland constitution, establishing a Chinland council and what is legislative, executive, and judicial power. And it's also coordinated with National Unity Government, but assert a distantly Chin political agency. And the third one is Kachin. We know that they have Kachin Independence Organization, KIO, which controls significant territory, has moved toward community-based pluralist administration following the Operation 1027, combining its civil servant with multi-ethnic community structures. So each of these is a different expression of self-determination. None is simply following the National Unity Government lead. They reflect community deciding their own forms of governance, which is, in a sense, what the concept of indigenous rights is fundamentally about. So for the last part of my presentation, I'd like to mention reason for caution. So our paper is careful not to overstate the opportunity, and I want to be honest about the headwind. The military divides and rule strategy is working in places. Some ethnic armed organizations have been drawn into ceasefire agreement that fracture the broader resistance. The pro-democracy movement is internally fragmented with competing constitutional vision and continuing tension over nationally for democracy, control of key bodies like the CRPH and NUG I mentioned, which itself generate minority dissatisfaction. So Myanmar also have a long history of failed peace processes that sideline minority voices under both military governments and also nationally for democracy government back in 2015 to 2020. So there is no reason to assume this time will be different without deliberate structural change. So at the tactical level, People Defense Forces and also ethnic organizations.
One minute.
Have different time horizon. So one focus on immediate resistance and the others on like long-term autonomy and operational integration between them remain fragile. So finally, many indigenous territory host multiple people with competing customary legal systems. So legal pluralism without coordination create real confusion on the ground, such as land tenure, resource management, dispute resolution. And without harmonizing mechanisms, these tensions deepen. So the tragedy of indigenous rights in Myanmar, in short, is inseparable from the outcome of the conflict itself. So democratic transition offers genuine possibility, but only if moved beyond symbolic stature, and the national unity government must actively dismantle deep-rooted structure of ethnic hierarchy, not merely dissent itself from the military rule. So lasting peace require structural transformation and not just region change. So I'm gonna leave it here, and I'm happy to take questions on legal framework and specific cases. Thank you so much. Have a good one.
Well, thank you, Sue. That was excellent. Thank you for a really interesting presentation and for sticking to time so perfectly. And thanks also to you, Jonathan, for your very interesting chapter. So we're now at the time for questions and answer. We have 2 questions in the chat. We have 5 minutes to discuss them. I'm going to amalgamate them both. They are both directed at Professor Hal-Sing in his presentation, but I want to invite Professor Nabi and Sue to weigh in if they have thoughts on these. Okay, so the question is as follows. If prior occupancy or first occupancy does not determine indigeneity, what are some of the parameters that could determine it? And what could be further steps that could be taken in India to articulate indigeneity in a more contextual manner? Over to you, Professor.
Yeah, my contention is not to suggest that prior occupancy or first occupancy are not, the basis of determining indigenous people or indigeneity. But my focus here is to problematize how this can be contentious when you have multiple and overlapping claims over, indigeneity, and this is precisely where the possible conflict between indigenous politics and discourse and group differentiated citizenship discourse in India is important. Because to the extent that if a dominant indigenous population use the discourse on indigeneity to deny or politically marginalize other non-dominant indigenous groups, then I think the way out would be to privilege group differentiated citizenship rights, which more or less in the context of Northeast India also cohere with the existing parameters of, the working definition of indigenous population that was developed by Jesus Martinez in the 1980s. So I think to that extent, it is therefore important that we have to contextualize and situate how these competing claims play out and reconciled with existing citizenship so that the absolute autocracy of the dominant group might not be perpetuated against non-dominant indigenous populations.
Thank you very much. Thanks, Professor Hal-Sing. We also have a question for Sue Tet in the chat, and that question is, to what extent do you think conflict dynamics in the ethnic states, particularly military divide and rule tactics, undermined the rights of Indigenous peoples to self-determination, governance, and the protection of their cultural and territorial integrity? Over to you, Sue.
So for the divide and rule is like kind of considerably, and it's because the divide and rule fracture unifying claims and also intra-resistant fragmentation diffuse who can't legitimately represent self-determination, and the plural legal system which erode the protection at the local level, and critically these three reinforce rather than offset each other. So that will be the short answer for the first question. Mm-hmm. And the second one is like to what extent conflict dynamic ethnicity, right? So for me, it's like so start with the divide and rule. One, the general piece of like individual ethnic organization into the ceasefire agreement. It doesn't just like fragment the military resistance. It directly undermines the self-determination. And then so there is a short autonomy at the process of the long-term self-determination problem flat in our paper. And the other one is like intra-resistant fragmentation that's sometimes different but equally damages. It diffuses the authority. And the plural legal system compound both of these at the ground level. So we have multiple indigenous groups, like I mentioned, more than 100. And they share contested territory under different customary framework. The absence of harmonization does not just sit at administrative confusion. So overall, these dynamics don't just slow the indigenous right progress because on the ground level, they actively redirect self-determination claim to the either dependency on the actors or the unresolved local contestation. So that's precisely why we argue lasting protection requires structural transformation, not just simply a change who hold in the central power.
Thank you. That was very clear, and thanks for the answer. I think we do need to have a break, even of a short one. So I'm going to propose now that we take a break for 3 minutes and reconvene at 3 o'clock, just so everyone can stretch their legs and get a cup of tea. So thanks to our panelists. If you'll join me in applauding or clapping or using your, however you want to express your appreciation. And we'll all turn our screens off and then reconvene at 3 o'clock if that suits everyone. Thanks again to the panelists. That was very excellent.
All right. Thanks, everyone, for attending today. We're returning to the presentations. So the first half was chaired by Kirsty, and then I am chairing the second half today. So the first presentation we have for the second half is from Professor Yuko Osakata. She is a professor of international human rights law at Chuo University Law School in Japan. And her presentation is about the rights of the Ainu within Japan. So Professor Osakata, are you ready?
Thank you, Johnson, for your kind introduction. I'm Yuko Sakada from Law School. First of all, I'd like to express my sincere appreciation to the editors for inviting me to contribute to this meaningful journal project. It was a great honor and pleasure to be part of it. My article in this journal, special issue, examines the ongoing Ainu lawsuit concerning some salmon fishing rights in the local river. On August 17, 2020, the Rapport Ainu Nation, an Ainu community in Urahoro, Hokkaido, filed a lawsuit with the Sapporo District Court. As a specialist in international human rights law, I submitted an expert opinion to the district court on their behalf. In the article, I discuss how solidarity with other indigenous peoples, particularly the Sami, has encouraged and supported the Rapport Ainu Nation in pursuing their claims. I also critically analyze the Sapporo District Court's judgment against the Rapport Ainu Nation. In my talk today, I will explain the background of this case, which I hope will help readers gain a deeper understanding of my article. So who are the Rapport Ainu Nation? The Ainu Association of Urahoro, a predecessor of the Rapport Ainu Nation, first came into the spotlight when it filed lawsuits against Hokkaido University in 2014. Sapporo Medical University in 2018 and the University of Tokyo in 2019, seeking the return of their ancestors' remains. These remains had been exhumed by Japanese scholars and stored at these universities. All of the cases reached amicable settlement, and the Ainu Association of Urahoro received the remains of 102 ancestors. In May 2017, during the course of these lawsuits, their representatives visited the Northwest Indian Fisheries Commission and other some American Indian tribes in Washington state. They learned how Indian tribes had recovered the right to fish salmon through litigation. According to Horiki Nakane, the then president of the Rapport Ainu Nation, they changed their association's name to the current one, Rapport Ainu Nation, in 2020 to more strongly express their desire to seek recognition of their right to fish salmon. Therefore, the influence of the Indian tribes in Washington state on this Ainu group is apparent. The lawsuits and rights recovery activities of the Ainu Association of Urahoro and the Rapport Ainu Nation have been supported by their lawyer, Morihiro Ichikawa, who received his legal education at the University of Colorado Law School from 1999 to 2002. In his book, he emphasized the necessity of learning from American Indian law in considering the Ain's possible native title, including the right to fish salmon. Its way of thinking has significantly influenced the lawsuit and the rights recovery activities of the Raporine Nation. Background of the Ain fishing rights lawsuit. The Ain relied on salmon as their staple food, and it was the most important fish caught in the rivers. They also used it for clothing and trading. The Ain hold salmon in high regard, calling it the divine fish. However, since the Meiji era, local governments have gradually banned salmon fishing in rivers in the name of environmental conservation. A general prohibition on salmon fishing in rivers still exists nationwide. In Hokkaido, there is a limited exception for the Ainu. Those who obtain permission from the Hokkaido governor may fish salmon only for their traditional ceremonies and transmit their traditional fishing methods. However, some Ain people consider such a limited exception to the sweeping ban insufficient and have challenged these regulations. The Raporine Nation's lawsuit presents one such challenge. The Raporine Nation's legal claim is based on its native title. However, as native titles have never been recognized either by national or local government or by any Japanese court, they grounded their legal arguments primarily in international human rights law. Their advocacy was actively supported by international human rights scholars, including myself, through the submission of expert opinions on their behalf. The Raporine Nation have also sought support from other indigenous peoples abroad, including the Sami. In May 2023, the Raporine Nation held an international symposium on the right to catch salmon in rivers as an indigenous right, inviting indigenous peoples from Taiwan, Australia, Canada, the USA, and Finland to Urahoro. Aslak Holmberg, the then president of the Sami Council, attended the symposium and a subsequent press conference with Masashi Sashima, the then president of the Raporine Nation, and Ross Jones, a hereditary chief of the Haida Nation. While the Raporine Nation have tried to internationalize their own movement and learn from the experiences of other indigenous peoples, it is also clear that they seek to generate international attention in order to apply pressure on Japanese national and local governments to recognize their salmon fishing rights. My article examines the struggle of the Raporine Nation, focusing particularly on their relationship with the Sami. This is because Holmberg, a Sami fisherman fighting for salmon fishing right in Finland, actively supports the Raporine Nation. Second, my expert opinions submitted to the Sapporo District Court on behalf of the Raporine Nation extensively refer to the Finnish Supreme Court cases on the Sami salmon fishing rights. My article also critically examines the judgment of the Sapporo District Court against the Raporine Nation delivered on April 18, 2024. It used this approach to identify the possibilities and limitations of litigation strategies involving international cooperation among indigenous peoples. Some follow-up information on the Ainu fishing rights lawsuit. Before ending my talk, I would like to provide some follow-up information on the Ainu fishing rights lawsuit. The lawsuit is now pending before the Sapporo High Court, and the latest hearing was held on February 3rd, 2026. 3 specialists gave the expert testimony at the hearing, and one of them was an Ainu professor, Dr. Mokotonas Kitahara. He made an opening statement called Kranke in the Ainu language, and then provided an explanation in Japanese. In this statement, he argued that ideally, court proceedings held in Yaomosri, the name, Ainu name for the land of the Ainu, should be conducted in the Ainu language with assistance of interpreters. However, he explained that as a result of the Japanese government's assimilation policies and the continuing dominance of Japanese language education, even most Ainu people are no longer able to speak.
Professor, 1 minute.
Okay, able to speak Ainu fluently. For that reason, he had chosen to speak in Japanese. He expressed the pain and regret he felt at being unable to address the court in his ancestral language. In light of these circumstances, he urged the judges to give the most careful consideration to how the customs and traditions established and preserved by Ainu ancestors must be accorded greater respect and recognition in the future. Some judges failed to understand what he was doing and even signaled for him to stop speaking in Ainu. When he was asked by the chief judge what was lacking for the Ainu apart from the right of salmon fishing, he answered as follows. There are shortcomings everywhere. When you heard the Ainu cranky at the beginning of these proceedings, some of you may have wondered what I was doing. Such a reaction reflects an underlying assumption that communication should naturally take place in Japanese. I hope you will recognize that this assumption itself a form of bias. The Ainu people still do not enjoy full and equal rights. The Sapporo High Court will deliver its judgment next month on July 2nd, 2026. Thank you very much for your kind attention.
Right. Thank you, Professor Osakata. That was exactly on time. I will now turn to the next presenter. So this is Dr. Lajado Lagyal. He is a Mackenzie postdoctoral fellow at the Asia Institute at the Faculty of Arts at the University of Melbourne, and his presentation today is focused specifically on China. So Lajado, are you ready to take the floor?
Yes, I am. Thank you. So the title of my article for the Australian Journal of Asian Law is Indigenous Denialism and State-Imposed Color Blindness, Mother Tongue Education in China. In this article, I use a descriptive and empirical approach to the issue of indigenous people in China's state education system, by which I mean, rather than arguing whether Tibetans are indigenous or not, I focus on the implications of a non-recognition of this indigenous identities of Tibetans, or in other words, what happens when a state denies the indigenous identity of its people in the state education system. So this article explored how the non-recognition of Tibetan indigeneity or Tibetan identity in China and the marginalization of indigenous Tibetans in higher education. So I look at their rights to a mother tongue-based education and the equal educational opportunities. So as a background to this indigenous issue in China, in 2007, China voted in favor of the United Nations Declaration on the Rights of Indigenous People, or UNDRIP, but denies that it has indigenous peoples in its territory, mainly the mainland China. The Article 13 of this document, UNDRIP, states that indigenous people have, I quote, the right to revitalize their histories, languages, oral traditions, and philosophies. And the Tibetans would qualify these guidelines and norms mainly because of their ancestral ties or the connection to the Tibetan plateau and their unique language, religion, and culture. So Tibetans are indigenous to the land that they live until to this day. But China, of course, denies that. And in China's the legal system, it uses a rather very let's say domestic term to describe these minority groups. That is the 少数民族. So 少数民族 refers to minority nationalities or minority ethnic groups. 少数 means 少数 means minority, but we would rather, in academic terms, we can also call them the non-dominant, which is in contrast to the dominant Han majority. So in in mainland China, the Han majority or Hanzu make up about 92% of the population, and then the rest of the 55 少数民族 or ethnic minority groups make up about 7 to 8% of the national population. So then the question comes, why China denies indigenous status of ethnic minorities such as Tibetans? Harvard historian Mark Elliott argues that there are two reasons that we can use to understand China's justification of its indigenous denialism. So the first one is that China fears that by acknowledging that Tibetans and others are indigenous to the land that they live, it would give rise to the separatist movement. That is, some minorities were accused of advocating or rather campaigning for the separatist movement, which actually is against the law in China. And then the second one is the human rights group. By acknowledging that there are indigenous people in China, it means that the UN human rights groups and other delegations have the right to visit these areas to see the human rights conditions and others. So for China, that is the quote-unquote intervention to their domestic issues or internal affairs. So China would not like that. So in my study, I find that I use this the academic term of a color blindness or colorblind ideology, which is a term that is used to refer to the denial or to the minimization of a race or ethnicity as a factor in the socioeconomic inequalities. So my study finds that the Chinese governments use a top-down, state-enforced colorblind ideology to promote this ethnic unity and the pan-ethnic Chinese identity known as a 中华民族 or Chinese nation. So this would effectively pressure minority groups to assimilate into the dominant Han culture of the 中华民族. So by adopting a colorblind ideology or policies, it reflects the denial of structural racial or ethnic discriminations and inequalities in China. So this China's state-imposed colorblind policies permeate various sectors, including the education. So China's political ideology of ethnic governance dates back to, according to scholars, the modern political ideology dates back to this China's sociologist and the scholar Fei Xiaotong's pluralist unity framework, that is 多元一体格局, meaning that all ethnic groups are equal the different bodies or different minorities. That would 多元 means multiculturalism or multi-ethnic the entity that would move. It's actually directional. That would move eventually toward this one body of nation, or 一体 means one body of identity. That is the Chinese nation. So what it means is that China simultaneously acknowledges this multiculturalism and multi-ethnic realities, but also enforces or promotes this one body of Chinese nation or one identity of Chinese the identity or nationhood. So more recently, scholars such as Ma Rong, who is a professor of sociology at Peking University, has promoted this second generation Minzu policy, which argued that China should depoliticize its ethnic identities. And which means that rather than treating ethnic groups as political entities, China should culturalize them. That is, to see them as cultural entities and to promote the cultural markers of ethnic groups and to de-emphasize the political aspects of ethnic identities. And more recently, there is this guiding principle of 中华民族共同体意识 in ethnic governance. That is the common consciousness of a Chinese nation. So basically, it is assimilationist ideology that would treat all ethnic groups as equal members of this umbrella term of Chinese nation or 中华民族. So empirically in my study, my field work was conducted at a Minzu University in the Western China, and I found that under these policies, there's no single policy that explicitly direct these practices, but rather under this the general trends, the universities of these Minzu institutions have dismantled the faculty of the Tibetan studies that they had, which offered Tibetan Chinese bilingual degree programs, and they consolidated these into different schools of languages, such as School of Tibetan Language, and all these consolidated degree programs now are housed at the Faculty of Chinese Language and Culture. So that means on the top you have a Faculty of Chinese Language and Culture, that is 中华民族中国语言民族学院。中国语言文学学院, and then under its this faculty, then there are different schools of language programs, such as the School of Tibetan Language and the Faculty of Yi Language, for example. So the implications of this is that these policies would exclude Tibetans from fully participating in higher education and exercising their language rights, because after these consolidation efforts, I found that the presence of Tibetan language in the curriculum has decreased, although it was not really prominent prior to the reform also. So in the past, at least they would have some forms of the Tibetan language courses, although there are more, let's say, the core courses were still in the Mandarin Chinese, no matter which major, which programs they were in. But after the reforms, the Tibetans have emphasized that the significance of their Tibetan language in the programs has overall decreased. And for example, they've pointed out that now all their graduation theses for undergraduate and graduate degree programs have to be in the Mandarin Chinese.
1 minute.
Thank you. In the past, they could write in a Tibetan language. So the implication of these reforms is that these policies exclude Tibetans from fully participating in higher education, and also to exercise their language rights in academic programs. And the institutionalization of cultural and social exclusion through this indigenous denialism obscures and hides the systemic inequalities that are associated with ethnicities. Thank you.
Thank you for that presentation and those insights. So we are now turning to a different part of Asia. The next presentation is from Dr. Lilis Muliani, and she is affiliated with the Research Center of Society and Culture at the Institute of Social Sciences and Humanities at the National Research and Innovation Agency of Indonesia. Dr. Muliani, the floor is yours. Thank you.
All right. Thank you very much, Jonathan, and good afternoon from Jakarta. Thank you. First of all, I would like to thank you for this opportunity to contribute in the special edition of the Australian Journal of Asian Law. Thank you, Kirsty, Jonathan, Pak Tim, Helen, and also the amazing team of the journal. So today I will be discussing the concept about the group legal personhood and examining the persistent legal stalemate surrounding the recognition of indigenous and customary, or in Indonesia, adat communities. This research is based on my thesis that looks closely at why a country with such a rich history of customary laws still struggles to protect the communities on the practical level. So let's dive into the core of the struggle. So yeah, to understand the current crisis in Indonesia, we have to look at the profound contradiction. So in Indonesia, we have the Indonesian constitution with the constitutional amendment in 2001 and until 2004. And also several sectoral laws that recognizes the adat communities as a legal subject. And also there are a lot of high-level political rhetoric frequently celebrate the cultural diversity and promise of the protection of the Adat community rights. However, empirical reality shows that this protection remains largely symbolic. While we have an incredibly wealthy repository of academic literatures and legal scholarship detailing Adat systems, Adat laws, and Adat communities' live experience, the reality of the ground on the ground is a continuous, devastating wave of land dispossession. And this creates a painful stalemate where communities have rights in the theory and in legal framework, but they actually lose their lands in practice. This reality is actually also supported by the compounding rigid legal structure and also intense pressures of modern economic development. In recent years, for example, the Indonesian government has aggressively accelerated the National Strategic Program or Project Strategis Nasional, or we call it PSN. And this includes mega infrastructure such as toll roads, dams, and also massive food estates such as the one in Merauke, Papua food estate, food and energy estate, and also the construction of the new capital city, Ibu Kota Nusantara, or Nusantara in Kalimantan or Borneo. This is also supported by the legal sieve brought on by the Omnibus Law, Undang-Undang Cipta Kerja. It is a state policy that has shifted entirely toward facilitating fast-track investment everywhere in Indonesia. So it's not, but mostly in Outer Java, yeah, in Sumatra, Kalimantan, Sulawesi, and also in Papua. And this has further prioritized the Adat Protection Bill, currently under the discussion at the National Representative Body, or the DPR RI, and dramatically accelerated the dispossession of communal rights and communal lands under the guise of the national progress. The theoretical and the conceptual and also legal framework, we consider it as a failure, and this has staggering real-world consequences. If we look at the data spanning from 2015 to 2022 in Indonesia, we witnessed over 4,000 major agrarian disputes, swallowing up nearly 12 million hectares of land, and majority of it are the Adat communities' land. And because the Adat or customary communities lack secure collective legal standing, they are left legally defenseless. When state actors or private entities claim their ancestral territories, the communities cannot defend their borders as a single legal entity, leading to systemic ongoing conflict across archipelago. So what is driving this stalemate in the applicable legal regulation and the issuance of the Adat Protection Bill? Particularly because the state only gives names to communities, but not the power to act. This is what makes it different. There is symbolic recognition as assumingly giving these communities genuine or substantive recognition as a legal subject. My research points to three main structural blockages in the draft bill stalemate. The first one is the legislative inertia, the highly anticipated bill on the protection of traditional customary communities, which has been stuck in political limbo and repeatedly delayed since 2014. And second, we see a shifting political landscape marked by elite capture, where the legislative focus has turned away from democratic inclusivity and toward economic and corporate interests. And third, there are fundamental flaws in our own administrative and land legislation system, which are simply not designed to handle collective fluid identity structures. So this is my favorite phrase from Pak Tim's chapter in 1999, very long time, but I always use this, a square peg in a round hole. So this discussion actually brings to a deep theoretical flaw in the legal design in Indonesia. Pak Tim has observed that Indonesian lawmakers continuously try to force square pegs into round holes. They take organic living, collective adat communities and adat tradition and try to squeeze them into a rigid, westernized individuals, European legal categories. When the state limits legal recognition only to what fits into pre-existing modern administrative boxes, it actively devalues and undermines the true nature of these communities. So there are actually three main entities that are recognized by the law currently that can register their lands. The first one is individuals, which is a natural person, one title per holder, but currently they are more people having more lands. And also corporations, a modern legal person designed for commerce, and a foundation, and also cooperation. Yeah, where does adat community the status? They cannot register, but they can only be recorded. The recording of the adat community's land is based on the latest Ministry of Agrarian and Special Planning Regulation number 14 of 2024, which only provide administrative records but not registration of the ulayat land, of the customary lands of the adat communities. So to solve this, we have to rethink group personhood, where our modern legal system is exceptionally good at granting personhood to corporation. The corporation is artificial, easily defined, and have clear administrative utility, and also fit perfectly into the state system. Meanwhile, the organic communities, however, are highly complex and bound by culture and generations, and mostly their laws are unwritten. And because they don't look like an entity in modern expectation, so the state treats them merely as a loose aggregates of individuals. The crucial question we must answer is, how can the legal system evolve to recognize these organic communities as distinct, unified legal entities without forcing them to act like commercial corporations? Currently, the state relies on a highly fragmented patchwork of recognition mechanism, which I have summarized in this table. Some rely on the regional regulations, but these are crippled by local political hurdles, while others look at the Ministry of Forestry Hutan Adat or customary forest scheme, which provides some relief but only covers fractional pockets of total territory of their customary lands. Finally, the Agrarian Ministry offers formal land titles under formal land recording titles under Article 16 of UPA, but this fails entirely because it is fundamentally built for individual owners, completely ignoring the collective nature of the adat subject or the customary subject. So the ultimate legal barriers is found in the foundational text of the first Indonesian property law.
Time to wind up, Lilis.
All right, just one more. Which is the Basic Agrarian Law of 1960. So this law explicitly restricts land titles to only two types of legal subject: natural individuals and formal legal entities, while adat communities doesn't fit. And so my recommendation is to propose add one category. So rights to land may be held by individuals, corporation, foundation, and collective group entities of customary land communities as a unified legal person. The community can hold title, can make contracts, and they have the power to exercise their rights. So this should move beyond symbolic recognition and give the community a seat at the registry. So in conclusion, the core takeaways of this research is clear. True recognition must reflect substantive justice, not just formal symbolic recognition and symbolic compliance to the constitutional norms. We must break the stalemate by designing a legal framework that embraces the collective personhood of organic communities as their own terms. So that's my article. So I would really welcome any discussion, and I'm incredibly honored to be able to contribute to this journal special edition. I hope this brings new power and fruitful discussion on the matter. Thank you very much. I'm giving back the time to John. Thank you.
Thank you for that. We are going to finish with a presentation from Mr. Gurley Ron Mahayunan. He's affiliated with, and forgive my pronunciation, but it's Idea Cipta Senandika from Indonesia. So, Mr. Mahayunan, are you ready for your presentation?
Okay, thank you very much, Pak Jonathan, and good afternoon. First of all, I would like to thank to the organizer, the Australian Journal of Fashion Law, for this opportunity, especially Pak Tim, Bu Helen, and Christy for the amazing works. And I'm excited to be part of this special issue. So my article on this special issue titled Strengthening Indigenous People Recognition and Participation in Indonesia's Just Transition. I want to start with simple problems. Indonesia has made a big climate promise through the Just Energy Transition Partnership. We call it JETP. Indonesia agreed to use less coal and to make renewable energy around 34% of its energy by 2030. On paper, this is a good and a serious plan, but there is a problem. The energy transition needs land, it needs forest, mountain, and open areas for solar, hydro, and geothermals. And much of that land belong to indigenous communities. But these communities are often left out of the decision about their own land. Let me give two numbers. By the middle of 2025, only about 7.8% of registered customary land was officially certified. And from 2014 to 2024, the Indigenous Alliance, or we call it AMAN, recorded more than 11 million hectares of customary land taken, almost 700 disputes, and more than 900 people charged as criminals, only because they defended their own land. So my question is simple. Can a transition be just if the people who own the land have no legal right to take a part in it? And my answer and the argument of my article is recognizing and protecting indigenous people is not small, is an extra issue, is a precondition and a basic condition we need first. Without legal recognition, there is no one to consult, no one to pay, and no one who can give or refuse a consent. Everything else only works if the community legally exists. In Indonesia, very often, it does not. And the just transition idea usually rests on three kinds of justice, like a distributive justice, are the benefits and the costs share fairly, and procedural justice, questioning does everyone affected get a real place at the table, and the rest is restorative justice, questioning our past harm repair. I argue there is a fourth kind, and it is the most important one for Indonesia, which is recognition justice. This means recognizing people's identity, their rights, and their way of life. Why is it important? Because the other three all need to recognize a legal subject first. You cannot share benefit with community the state does not accept. You cannot give procedural rights to a group with no legal standing. you cannot return land to people whose claim was never registered. So recognition is not just one of the four; it is a gate. The other three must pass through it first. And now I come to the legal core, the place where Indonesia system breaks the international rules, ILO conventions 169, UNDRIP, the World Bank ESS 7, and IFC PS 7, and the ADB safeguard policy all share one main idea, like self-identification. A community can identify itself as indigenous. The state's job is to accept it, not to give a permission. Indonesia does the opposite. Here, recognition is given by the state. A community becomes masyarakat hukum adat, or we call it customary law community or masyarakat hukum adat, after bupati or mayor sign a formal decision. Before that decision, the community has no legal status, and its land can be treated as a state land. This creates a real contradiction inside Indonesian's own law. Article 18b, paragraph 2 of the Constitution recognize customary communities and their rights without asking for any formal decision. But the regulation below it to ask for that decision before any rights begin. The Constitution says recognize only or confirm what already exists. The regulation say recognition is what creates the rights. Both roles are active and at the same time. And there is more. The Home Affairs regulation and the newer Land Ministry regulation define a customary community in different ways. Both are still valid. So we have a confusion in the law on top of contradiction in the Constitution. For most of the last 10 years, the solutions, special masyarakat adat law, was stuck. It first entered the legislative plan in around 2014 to 2015. It then went nowhere through for government. But here I can add something new, something that is not in my article because it happened only in the last few months. In early 2026, the bill, the Indigenous People Bill, is back on the national priority list, or we call it a prolegnas. Parliament has held a public hearing with indigenous representatives from across Indonesia, and this is important for my argument that they changed its name from masyarakat hukum adat to masyarakat adat. Yeah, this moves the term close to the international idea of these people. People citing no hopes the bill will pass this year, but we are not sure it will. It has been delayed before. But the momentum is real, and it makes my article timely in a way I didn't expect when I wrote it. And let me make this real. Let me give you one example. The strongest example is not from mining. It's from renewable energy project, a project that called itself inclusive. For example, in Isumba, community-based renewable energy projects were presented as a fair and empowering, but in real life, the decisions were controlled by traditional elites and village leaders. In one village, the lower status member, the Atta people, gave their labor through communal works, and then they were refused the electricity that came from it. In another solar project, the power went to richer central area, but the poor household at the edge got nothing. So what does a better model look like? My article looks at 3 countries like Canada and then Australia and Chile, which has ratified, especially Chile, which has ratified ILO 169. So indigenous people took part in solar project at every stage, like the planning, building, and monitoring. They share one pattern, which is a legal protection, plus a real economic rules, plus respect for traditional knowledge. So what do I recommend for step very kind of briefly? First, pass the masyarakat adat law and add a clear specific rules for public consultation so that participation is real, not just a formality. And the second, bring FPIC or free prior informed consent into the transition process, not as the only tools. And I know the political will is limited, but it will be the guiding standard for projects on indigenous land. The third, move toward the international framework, apply UNDRP in practice comprehensively, and engage seriously with ILO 169. And the last, make this truly share work, governments, companies, civil society, academics, and community as rights holders, not as people informed after the decision is made. Let me end where I began. The heart of just transition is one phrase, leave no one behind. For Indonesia, that promise is being tested right now. Yeah, this year in the parliament, recognition is tested. If the communities whose lands power the transition cannot legally take part in it, then it is not a just transition. It is only transfer with a new name. Yeah, thank you for the 10 minutes that given to me.
Thank you so much for that. And thanks once again to all of the presenters for the respective insights on the presentations. We are now turning to question and answer session. So the question, and maybe this is for each of the presenters that we've had in the second session. The question is, how should the relationship between indigenous peoples and state law be conceptualized? Are indigenous peoples communities whose rights are dependent on state recognition, or are there inherent rights and indirect authority through customary law and self-governance? And so so I had a very similar question myself, and I would like to get a comparison from each of the different presentations regarding the author's perspective. So maybe we'll allow all of the authors to respond to that particular question. And maybe I'll call upon Professor Osakata first, and then we'll take turns in order to Lajado, and then Professor Miliani, and then Mr. Mahayunan. So Professor Osakata, why don't you go first, please?
Thank you. Thank you for your very interesting but very difficult question. And actually, in Japan, Ain people not recognize any rights by the government, by the national government. So now they are trying to seek their rights based on customary law, or native title. But as customary law or indigenous customary law or rights or native title are not recognized by the Japanese court yet. So now what they are doing is to rely on international human rights. But on the other hand, there is a kind of activities that Ain people are trying to figure out their customary law by themselves with the help of NGOs. And I think that is quite important project. And thank you so much.
Thank you. And then Laja, did you want to follow up?
Oh, yes. So in my just personal observation, in a non-liberal state like China, if the state doesn't recognize, so in ethnic issues are highly, let's say, governed and regulated by the government. So when the state does not recognize the indigenous movement or indigenous activism, I think there's really no operational space for individuals or groups to exercise their rights. So I think in China, it's very dependent on the government's at least some forms of acknowledgement, or let's say or the permission to conduct these. Thank you.
Thank you. I would like to actually just have a slight modification of the question for both Professor Mulyani and Mr. Mahayunan, because they're both focused on Indonesia. So I'm very curious about the respective differences regarding prescriptive solutions. So with respect to this question, because I think both presentations in Indonesia highlighted this issue about the state recognition of indigenous communities and state recognition of the rights that are tied to legal communities, indigenous communities. I'm just curious about the kinds of solutions that each of you prescribes. So why don't we go first with Professor Mulyani, like in terms of what solutions do you think are appropriate to deal with this issue?
Thank you, John. So I also would like to point the question from the question and answer. So I think normatively there have been numerous guidelines for recognition from in the international human rights instruments, and also national recognition, particularly in Indonesia, because normatively we have the constitutional recognition. We also have several laws, sectoral laws, such as the forestry laws, the regional or decentralization or regional government laws, which also recognize the existence of the indigenous or customary communities in Indonesia. However, in practice, they are often insufficient to provide secure protection. And I think sometimes most of the recognition is divided between the personhood or their subjectivity as a legal subject within Indonesian law, and others only securing the territorial rights or the ancestral rights of these communities. So they are being separated sometimes, while we need something that is very comprehensive between giving them the rights or the recognition, the acknowledgement as a legal subject, and also the acknowledgement to their rights to the territory, rights to governments, and everything. And so I think state recognition top down is not enough. We need a multi recognition, not only one way from the state, but also from the community themselves. And in my thesis, I also wrote about relational recognition, which is the needs for the community to get recognition from the surrounding society. So the society and the community that has the relations, daily relation with the community, the indigenous community, they acknowledge them as an entity. And also the relational in terms of their relation to the environment, to the land, to the forest, or to the nature is also important. So I think it's not about one way of recognition. There has to be a multiple way of recognition, which gives them more secure protection. Mm-hmm. I hope that helps.
Okay, thank you. Yes. So now we'll compare that response with Mr. Mahayunan. You'll have the last answer, and then we'll go to closing.
Yeah. It is interesting if we discuss the indigenous people in Indonesia. Because Indonesia has the other terms, we call it as customary law communities or masyarakat hukum adat. So to be recognized as a legal subject, they should have like a decree from the region or major. So they are recognized and protected legally as a subject law, and then they have like authority to control their territory, or we call it as hak or collective ownership of land. And the recognition in Indonesia, especially regulated in the Ministry of Home Affairs, number 52 of 2014, that is still valid. And I think it's very procedural, because there are some criteria that need to be verified by the committee appointed by the ministry to determine whether they are meet the criteria as a customary law community or not. But a different context when the company has like a project in the remote area in the customary territory that has international financing, like from ADP, and then from the World Bank, and then from the IFC PS7 that has their own criteria to determine these people, which is a self-identification. So there is a sophisticated when we identify based on the international standard, they meet the criteria as indigenous people. But if we refer to domestic law, they haven't meet the criteria as the indigenous people. So I think, this is the political will to ensure the alignment between the UNDRIP and then ILO 169, and also to adopt international standard like ATP, World Bank, and IFC, because all the renewable project in Indonesia also they mostly use that standard.
So thank you for that answer. And I think the last two speakers, you finished off responding to two of the questions that were in the Q&A space as well. So I think we've reached the end, and now I'll turn the floor over to Helen Pausaker for closing comments. And thank you to everyone.
Thank you very much, Jonathan. And it's my privilege now to thank everybody who's been involved in this seminar. Firstly, to the speakers for all the work that you've put into your wonderful talks, and also into your articles. And I will miss everybody because we've had so much correspondence over the last year. And thank you also to Jonathan and Kirsty, who have put so much work into editing the edition and to chairing today. So I think we can collectively all be very proud of the issue that's been produced, which has involved everybody working together in such a wonderful way. And I'd also like to thank my two colleagues, Catherine and Tim, and to say what a pleasure it is working with you two as well. And this seminar could definitely not have happened without Catherine behind the scenes, pulling all the levers to make sure it works. And the issue itself would not have happened without Tim pulling his levers, different sorts of levers. Finally, I'd like to thank the audience because there's no point having a launch if you don't have somebody there to look at it. Otherwise, you're all just patting your own backs. So thank you to everybody for turning up on your computer screens and taking part in this launch. I think this has been one. I'm not a huge fan of Zoom, but I think being able to have these launches with different people all around the world and to meet all the authors in person as well as on the page is one of the absolute delights of having Zoom. So thank you to everybody, and I'll call this now closed. Thank you.
Thank you.
Thank you very much, everyone.
Thank you very much.